Honourable Maliswa, as chairperson of ANPAC, you were recently quoted as saying that legislators, government officials and ordinary citizens who fail to report corruption at all levels are doing a disservice to the nation. It appears, and analysts concur, that even when corruption is reported, nothing appears to be done about it. We did hear from the Deputy Commissioner, Zach, earlier. I cite, for example, the 2019 Auditor Generals report showing alleged corruption in both local authorities and state-owned enterprises. So, Honourable Maliswa, in your view, what is the scale and impact of public sector corruption in Zimbabwe?
Thank you very much, Andy. I think most of the reports from the Auditor General's office talk to that. In terms of the level of corruption. And I think what is also important is to appreciate that there's nothing that's done. I think the previous speaker, Dr. Moyo, spoke about being on a treadmill. You are running the same position, but the position is not changing. So that, I think, is where we are as a country, where I think there's no more confidence in the public. And institutions like ZAC, who have been aggressive and I think have been doing a good job, are fought back. And fought back through a smear campaign, myself included. The more you expose it, the more enemies you create, and the more you're fought back. But it can only give you determination to be able to do that. The public itself, we need to revisit our DNAs as Zimbabweans, that we won the struggle against racism, against the Smith regime. But where is the DNA to keep fighting corruption if we were prepared to sacrifice our lives for this country? Why are we not sacrificing ourselves to expose corruption? I've always said that failure to expose corruption bites you too. As a politician, I've said, I see people who say, I didn't vote, and they actually have drinks, they pop champagne for not voting. But when the economic hardship hits you, it does not dissect those who voted and those who did not vote. You suffer the same consequences as those who voted. So my appeal to the public really is to say, we've got to really visit the founding principles of the struggle of our country. And that, I think, will put us in a better position despite the forces that at play. I've always said that I will speak even if nothing happens about it, but the records will remain.
Honourable Minister, before I move on to Commissioner Makamure, there is a huge impact of corruption, for example, on the budget, money that's allocated for various services or various infrastructure projects. And of course, some of that money is being lost through corruption. And also, of course, the provision of services to citizens, and of course the corruption and the impact it has on citizens' taxes, because the government needs to raise more and more money as more and more is leaked. What would be your comment to those views?
If we have to be honest, the biggest problem we have, and I see Honorable Mshoriwa is here, Honorable Mtambisi is here as legislators, we burn midnight candles to pass the budget. We burn midnight candles to pass the budget. This ministry must be given this much, Parliament must be given this much. Only 30% of what would have been approved is given. That's the source of corruption. The Minister of Finance must be honest and say, I've got 2 billion only. And the 2 billion I have, I can only disburse so much, and it is disbursed immediately. And the biggest corruption and the biggest fraud ever is from the fiscus itself, from the Minister of Finance, who promises money to government entities, to Parliament, to institution, yet it does not disburse the money. So if you're short of 70% and you're given 30%, what do you expect people to engage in? Corruption. So let's not beat about the bush. Give people all the resources that they need. Once you give them the resources, then ask them to account. But if 30% is what is given to everyone, then the other 70 people are short, they'll resort to corruption at the end of the day. I've always said that is the biggest problem we have, in that the Minister of Finance does not disburse the monies that we would have agreed upon timelessly It does not come back to the august house for a supplementary budget considering the inflation which is there. So everybody is so changed. So everybody resorts to corruption.
Thank you, Honourable Minister. And it will be interesting in the launch of the report later to actually understand exactly how many people in Zimbabwe have been subjected to paying bribes or corrupt practices and who has done that. So we look forward to that report launch later. Commissioner Makamure, the Speaker of Parliament, Advocate Jacob Mudenda, was quoted as saying that although ZAC and other anti-corruption agencies are exposing, combating and eradicating corruption and the abuse of power by those holding political and public office, he went on to say, and I'll quote, he said, ZAC has been found wanting in a number of areas, which include the catch and release, as well as for the lack of teeth to prosecute high-profile figures allegedly caught up in corrupt activities. Commissioner, you've cited the AG's 2019 report, and I believe your commission has, and of course in that alleged abuse by local authorities and state-owned enterprises, their corrupt activities was highlighted. Perception is, however, and I think it's unfortunate the Deputy Commissioner is here, but you're the spokesperson, is, however, that ZAC is not addressing issues or taking action raised in the report as it relates to those two areas. Your comment, does ZAC lack the teeth to prosecute or investigate properly?
Thank you very much, Andy. Let me say that the Commission has got teeth that bite. I think it's very important to understand the mandate of the Commission. The mandate of the Commission is to investigate cases of suspected corruption for prosecution and asset recovery. So that is the investigation side. Then the other very important, equally important component is prevention of corruption. So when we investigate, we prepare dockets, we submit to raise a year to prosecute. But we are all agencies who work in the criminal justice system. So we work together. We have an MOU with NPA, we have an MOU with ZRP, JSC, and many others, because we believe in the collaborative approach. So, in our investigations, we bite very, very well. And we prepare the dockets, and we are not afraid to tackle even very high-profile corruption cases. And evidence is there. There are cases before the courts at different stages. So that's our mandate. But we have an interest to ensure that there is successful prosecution, but we don't prosecute. But we have an interest to make sure that our investigations are thorough, that the dockets can lead to a conviction. So the Speaker, when he said has been found wanting, it's not that we are not effective in our mandate. I think I was in that meeting in Bulawayo. He referred to other issues, not necessarily that the investigations, the mandate that we're executing, we are not doing it, we are found wanting.
But Commissioner, so, what would you say, sorry to jump in there, but what would you say to those who say that we've received the 2019 Auditor Generals report, and I'm sure we've had the 2018, the 2017, in there is highlighted corruption in the public sector, yet now you talk about your mandate of prosecuting and getting people to Mr. Reza there, but we're not really seeing people getting to Mr. Reza there based on the reports or the information contained in Madam Chiri's reports.
On the contrary, Andy, we are very much seized with the Auditor General's reports. And we're actually working very closely with key institutions like the Public Accounts Committee of Parliament, the Auditor General herself. We have got an MOU, and the Deputy Chair, in his address, he referred to the issue of Auditor General's reports, what we have done so far. We do look at the Auditor General's reports. We identify cases or issues that relate to corruption. So what I want to say here is, not everything that the Auditor General says is corruption. So when the report has been produced, we do an analysis and we pick out issues that we believe are corruption related. Then we follow up on those issues. We have conducted several roundtables with senior officials in ministries, in local authorities, in various government departments. There are cases that we are currently pursuing arising from the Auditor General's reports. I can't divulge the details, but there are several that we are currently pursuing. And it's not only the annual report of the Auditor General, it's also forensic reports that are produced from time to time. We are seized with all that.
I mean, just an aside, reading the Auditor General's report, it appears that there are instances across most local authorities, there are instances across a lot of state-owned enterprises. I won't mention some of them, but I think ZESA is one that comes up in the report all the time. Manpower, resources, I mean, this is a lot of work to go around all the different local authorities around the country as well as the state-owned enterprises. Can you do it?
Yes, we can. You see, this is why this commission has pursued a collaborative approach. Because on our own, it's very difficult, I agree with you, but through collaboration. So, TIZ, let me give an example, is one of our key partners, and I want to commend TIZ for not now becoming armchair critics. They are quite very proactive. So we leverage on resources of various partners to be able to tackle this mammoth task. Yes, without doing that, of course, we want to commend government for trying under the circumstances to avail budgetary resources to the commission, but the funds are never adequate. So we need to be working with various partners, leverage on their resources. This is why we came up with the National Anti-Corruption Strategy, which is an implementation framework that tries to give meaning to this collaborative approach, where a stakeholder is actually given space to lead certain initiatives under the framework of the National Anti-Corruption Strategy. So yes, that is a better way of trying to address
so in fact,
resource constraints.
It's why we're here as an Indaba. All stakeholders here, all committed to working against corruption and also dialoguing and communicating transparently. Let me come to you, Mr. Reza. Michael, and I know we've had conversations about this in the past, but this issue of catch and release, it's been cited numerous times as one example that sends a message that corruption can pay. This is my first question to you. What would be your response to that criticism? I know we've spoken about this before.
Thank you, Andy. At the outset, let me say I remove my tattered hat in salute to the quality of dockets that are coming from ZAC and the Zimbabwe Republic Police. The evidence is overwhelming. Corruption and fraud are crimes of deception. What these people do when they have stolen the money, they've, up to a certain point, succeeded in hiding that money very well. But as I said earlier, ZAC and ZRP have been able to go behind and find that evidence. It is now there in the dockets. We have now come to the problem which you refer to catch and release. We are obliged to send all documents, every piece of information that we intend to use, we give it to the accused person. So he or she sits down with his lawyer. They go through and see what defense they can possibly mount. They find they have none. All the evidence is there. The prosecutors are there. I have referred to this on another forum. there is creeping into Zimbabwe and other countries as well a new phenomenon called the Stalingrad defense mechanism. This is a mechanism where the lawyer will make an application at each and every stage. And when I say each and every stage, I mean it. They will start by making an application against placement on remand. We oppose it, and the court rules against them. They make an appeal to the High Court. They will then make an application challenging, saying the judge does not disclose an offense. They will make another application saying this, they will make an application for that. Let me hasten to add and say, all those applications are provided for in the statutes. The lawyers are very careful. They will not make an application which is not provided for, but they will make some of the most unmeritorious applications you have ever seen. Currently I'm dealing with a case, Andy, where the one accused person is represented by 4 lawyers. 4. One of them is an advocate. What they've said is each one of those lawyers has a specific role that he is playing. So if he or she if he is not there, trial cannot proceed because who will be doing his work? Sometime last week we had to remand the case, but we are waiting for a ruling. That trial is not likely to go anyway. And let me say as well, the Constitution, the current Constitution says an accused person is represented by a lawyer of his own choice. So if he says, I want to be represented by lawyer X, and the lawyer X says he is a matter in the High Court, what it simply means is the magistrate's court case is put aside until such time as that lawyer is available.
Michael, I'd like to jump in there because it's the issue about catch and release, I remember in our discussion, was that under our Constitution, everybody is allowed bail. Is this correct?
That is correct, yes.
So therefore, when we say catch and release, if someone's arrested, they go to court, but they can ask for bail and normally would get it. And so therefore, it's not really a catch and release, is it? So that brings the question then, is that should we be looking at, through the parliamentarians here, some form of legislation that closes that gap, particularly when it comes to corruption cases? Is that something that the MPA would recommend, for example, to the authorities to consider?
Before the coming into operation of our current Constitution, the accused person on arrest was the one who was supposed to make an application for bail. The current Constitution says, as soon as an accused person walks into court, that person is entitled to bail. The state must prove that that person is not a suitable candidate for bail, and that is a mountain to climb. But as you can see, there are so many of accused persons who have been denied bail. It comes to a point where sometimes I've had to say in Shona, kana zvaoma kushanda nepfungwa ndotoshanda nesimba, so that we ensure that this phenomenon of catch and release does not appear. But the people are being granted bail. And when they've been granted bail, and the lawyers are making all this, the people out there, they read that so-and-so has been arrested. A week or later, they see him walking the streets. And 9 times out of 10, they will say, don't worry, everything is sorted out. I've spoken with the prosecutor, I've spoken with the magistrates. And they will be lying through their teeth.
I think this, I suppose, throwing that back to the legislators, to Parliament, to see what can be done. Yes, please, if you do you have the microphone there? Very quickly.
I think this is where the show begins. You were sitting on over 300 dockets from Zach, and I thought Zach would bring this up. Over 300 dockets. The NPA was sitting on them. There's a waste of taxpayers' money. It's only now that the acting Prosecutor General has dealt with at least over 100. So why were you sitting on 300 dockets? If you're telling me that there is collaboration, and this is where ZAC has been found wanting. They are now attacked for arresting, yet they don't prosecute. The Prosecutor General's office is the most incompetent ever. I've been arrested over 70 times, acquitted over 70 times. In any country, the Commissioner General, the Prosecutor General would lose a job because the waste of taxpayers' money. Imagine 70 cases and you are acquitted and you stand in court. The cases that you pursue are political. You're arresting people like Hopewell on flimsy charges, yet money is being stolen by the politicians. Us politicians are stealing, and you're not prepared to touch us.
Okay.
You are receiving instructions from politicians. Let me be very clear. We will never achieve this. Dr. Moy talks about political will. There is no political will because the Minister of Justice is a political appointment, and you have got to consult him in terms of the act. NPA is not independent. ZAC is not independent. There is no institution which is independent as long as you say it must consult the minister. The minister belongs to a certain party. He will never allow his party to be exposed because they will lose power. So let's be honest. Why were you sitting on 300 dockets, which ZAC has done, a waste of taxpayers' money, and you think as Parliament we must support that?
All right, thank you, Honourable. Michael, of course you're going to respond, but when you respond to Honourable Maliswa's comments, I think he's brought up something which I was going to ask you, but I might as well ask you now. It's this issue of the perceived hesitancy by the National Prosecuting Authority to prosecute political or politically elite-connected people. I think that's the impression. I think Honourable Maliswa has put it from his opinion there. So I think the question is, of course, responding to him, but the question is, do you tread softly when it comes to dealing with corruption involving political elites? I suppose it also applies to ZAC. I mean, it appears that some allege that some high-profile cases are never really successfully prosecuted, even though there's huge announcements in the newspapers that such and such has been arrested, nothing really happens. So, Michael, maybe you could respond to Honourable Lisa and also that comment.
Thank you very much. Let me start by saying it is not correct, with the greatest of respect, Honourable, to say that the NPA was sitting on over 300 dockets. That is not factually correct. The situation is we have dockets that have come from ZAC, we have dockets that have come from ZRP. They are at different stages of prosecution. We cannot rush and say we want to make people happy, we are going to take people into court when there is an application which has been made. We can do it, yes, but what is the end result? The result is that when that person takes that matter on review to a superior court where he was denied to make an application in court, what the judge will simply do is he will rule that it was a mistrial. And when that happens, the judge can only make one ruling, which is not guilty and acquitted. And let me tell you this, ZAC and police will have done their work. They will have investigated. If I sit here as acting Deputy Prosecutor General and I allow something that I know is going to kill a case so that I make people happy, I will be failing in my duty. I stand here, you can lambast me, but if an accused person, if of the 300 dockets, 50 of them are subject to an application, I shall instruct my subordinates to respond to those applications appropriately. Wait for a ruling, and then when that ruling is given, then the matter can proceed. Let me now go and address, Andy, very quickly, the issue that the NPA...
Treading softly with political elites. The people are saying that NPA maybe treads too softly with political elites when it comes to corruption cases.
Very well. I do not know what that means when they say they are treating them softly. Are they saying we are consenting to them being admitted to bail? Are they saying we are not prosecuting effectively?
Yes. I think that is what the analysts and commentators are saying.
Let me say this. When a matter comes into court, there is always that possibility that a person is going to be either acquitted or that person is going to be convicted. Let me, without mentioning, without saying anything in particular, but let us suppose a person is arrested. He is a politically exposed person. He is arrested. He comes to court because there are allegations that he gave an unlawful order. ZAC arrests that person. That person comes to court. Now, when the investigations are completed, it turns out that there is nothing written that the person said, go and give a contract to this company. There is nothing written. All what we are saying is what we read in the press is he gave an order to say grant contract to this company. Where was the instruction? And his defense is, I never gave that instruction. And you want the NPA to manufacture from Norway evidence and say you gave that so that I make you happy. How can you do? Suppose it happens to you.
So Michael, let me jump in there. So are you saying the MPA has no fear or favor? It doesn't matter who that person is, how high they are, whether they're politically connected, minister, for example, you will prosecute based on evidence. Is this what your assurance is to this Indaba?
Andy, read my lips. His Excellency, the President of this country, has said there will be no sacred cows. Who am I to sit and say that one is a sacred cow? That when His Excellency himself has said there are no sacred cows.
Okay.
And let me just conclude by saying, as I sit here, I have never, and I repeat never, been given any instruction by any politician to say that person must go to prison or that person must be set free. Not even across the road. I have not spoken to any politician who has given instruction.
All right. I know Commissioner Makamura wants to come in, but before you do, John, Mr. Gondo has been sitting there quite patiently as he listens to the two of you.
What I want to say is related.
Okay, very, very quickly, if you can.
Yeah. As far as ZAC is concerned, will investigate suspected corruption without any fear or favor. And examples abound. Several cabinet ministers, it's in the public domain, have been arrested, lost their jobs. Senior government officials have been arrested, lost their jobs in the private sector as well. Senior people there have been investigated. So on that, in that area, as far as ZAC is concerned, there is no interference. Yes, and then what he was saying is you have to prove beyond any reasonable doubt that an offense was committed. This is where there is a problem, beyond any reasonable doubt. If someone is given a verbal instruction that you have to give Makamure a tender, how do you prove beyond any reasonable doubt? So that's some of the challenges.
Okay.
But I'm interested in a way forward. The deputy chair, in his address, he spoke about looking at court rules. So this issue has been debated over and over again. And even in the National Anti-Corruption Strategy Steering Committee, which is a high-level committee, the issue was on the agenda. And it was agreed that we need to look at court rules.
Okay.
And the work is underway so that we have stipulated time frames by which corruption matters are dealt with, so that even if there are these frivolous and many of these applications, you know that within 12 months or 6 months, the matter has to be finalized. So if we must all support those reforms, because there is an acknowledgement there is a problem, and there are reforms underway. This is where, us as stakeholders, we must come in and support those reforms, then we'll be able to deal with that problem.
Thank you for that, Commissioner. Mr. Gondo, thank you for being very patient and waiting there, because, of course, you represent the Procurement Regulatory Authority of Zimbabwe, which is a critical component. Because I'll give you some numbers. In most developing countries, public procurement constitutes an average of about 5% of GDP, as well as about 20% of public expenditure, which in Zimbabwe's case may run into billions of dollars, if I can put it that way. Public procurement processes, of course, provide governments an opportunity to ensure it obtains goods or services at the best price or quality, and that the process of obtaining them is, and this is the key, transparent and competitive. We're looking at the 2019 Auditor Generals report as a good example, showing some of the systemic holes in public procurement amongst local authorities, as well as state-owned enterprises. And of course, I refer to the Public Procurement and Disposal of Public Assets Act, which is, I believe, one of the defining legislation that defines procurement in Zimbabwe. But commentators state, sir, that controlling corruption is a key goal of public procurement, legal and institutional frameworks, complemented, of course, by the criminal justice system, the police, the prosecutors, and so forth. But something appears to be lacking if we keep on seeing these alleged procurement misadventures, if I can call them that, in local authorities and state-owned enterprises. Your comment.
Thank you very much, Andy. Suffice to start by saying that we do have a reformed act since 2018, which is very much in line with international best practice. My personal feeling is the way we interpret these figures that you have just given. The fact that the Auditor General actually goes and highlights these issues as misprocurement, it means that we've got a system, we've got standards that are set. We work hand in hand with them, and maybe the challenge now is, what are we doing about those issues that have been highlighted? But in terms of the legal framework, the institutional arrangement, the government of Zimbabwe since 2018 has professionalized and decentralized public procurement. By this I mean that the state entities, the state-owned entities are now responsible for their own procurement. Unlike in the past where you had a state procurement board, you now have PRAS as a regulator, as a referee. So the rules are now clear that the heads of the government institutions, the ministries where you have headed by the permanent secretaries, are now accountable for the manner in which they conduct procurement. The rules that we abide by, like I alluded to, are very much in line with the international best practice. In terms of implementation, in terms of transparency, we still have some way to go. Best practice now dictates that you also have to use electronic means to conduct a public procurement so that there is greater transparency. So far, in terms of transparency, what we can just talk about are issues to do with publication of tenders. The rules do not allow that tenders are issued in secrecy. Contract opportunities must be afforded to all potential bidders. We also need to advertise the results of a tender in the same manner that would have advertised the opportunity for the tender. That is being done in the mainstream media. But we need to go further, and this is what, as a regulator, we are working on, introducing what we call electronic government procurement systems. Currently, our systems are still very manual and subjected to a lot of human interference. So these are the challenges that we are working on, and
so when you say that and you're working on these timelines, because as I said, we're talking about billions of dollars of public procurement, and it has a huge impact, of course, corruption, particularly local authorities, not just in state-owned enterprises, but local authorities in particular. The Auditor General's report shows numerous cases of procurement infringements in local authorities, rural local authorities, as well as urban ones. What is your timeline? How quickly are you working towards plugging at least the majority of these holes? We appreciate that leakages always exist, but how quickly is PRAS doing this?
The government of Zimbabwe has taken a deliberate step. When the reforms were done in 2018, the World Bank and other funders had promised that they will fund the e-government procurement system. Somewhere along the lines, obviously, due to reasons best known to them, the offers were withdrawn. But what we are currently doing is using our own internal resources funded by Treasury. We are now implementing electronic government procurement systems in a piecemeal fashion. I think by the end of the third quarter, we should now be able to have a system that all registered bidders, if say an entity such as the ZESA wants to procure vehicles, all bidders that are registered with the Procurement Regulatory Authority should be able to receive notification of that tender. Yeah. But I must also hasten to say that we cannot talk about transparency without also alluding to the issues of integrity. You know, the current piece of legislation affords losing bidders the opportunity to challenge the procurement process at any stage of the procurement process. From the way the bidding document is designed. By this I mean from the way that people describe the things that they want. Things can be described in such a manner that they favor a certain bidder. You know, so so there's very much there are very much provisions for enhancements of integrity. They can challenge the bidding period, that it is too short, we need more time to respond to the tenders. They can challenge the outcome of a tendering process, because the law provides that before awarding a contract, you must the state entity must notify all the bidders that they have lost and that bidder A has won, and if they've got issues with that, they've got a window period to challenge that.
Mr. Gondo, obviously your PRAS cites the Auditor General's report, and you notice some of the anomalies raised by the AG in terms of procurement. How closely does PRAS, or does PRAS work in any way with agencies such as ZAC or the MPA and investigate some of these alleged anomalies, particularly coming out of the AG report?
Yeah. Again, we have to be guided. All statutory institutions, such as PRAS, the functions are defined in an act. We have certain functions and we've got certain powers. We do have investigative powers where we feel that procurement processes have been violated. We work closely with ZAC. We do have an MOU, and incidentally, we're actually trying to come up with a training program for involving all stakeholders in law enforcement with respect to procurement processes. So we do work closely with other law enforcement agents. And I must also hasten to say, we work closely again with Transparency International Zimbabwe in trying sometimes to help in terms of even such things as funding some of these training. So we work closely with even the Auditor General's office.
Thank you. Honourable Moliswa, I want to come to you because I think you'd have some strong views on this issue of lack of political will when it comes to prosecuting so-called political elites in Zimbabwe. What are your views on that?
You see, we need to collaborate honestly. Zach, it would be unfair for you not to tell this crowd how many dockets you've given the NPA. I think it would be totally unfaithful and insincere of you. We were together in Bulawayo with the Prosecutor General's office. Honorable Chamisa is here. When I talked 200 dockets and the speaker corrected me and said over 300. I don't want to be a legislator who's like somebody who's not honest. We are dealing with issues, and for you not to say to the crowd the truth of the dockets you've given NPA, you'd have failed your job. That's corruption on its own. And you must, Mr. Makamure, you must be able to say it because you've been coming to us as parliamentarians to get this to happen. And can you be honest and tell Mr. Reza how many dockets were sitting, and now since there's a new acting Prosecutor General, how many have started moving?
All right,
because I think it would be insincere and totally corrupt of you as an institution if you do not report that. The vice chairperson is here. We need to be honest because we risk, by me saying that I'm risking my own life for the good of the country. And we must be honest, this is not a joke.
All right, well, let's Commissioner Makamure, I think that deserves a response.
Thank you very much, Moderator Andy. In 2020, we had a target of 80 commissioners a year. They will correct me where I'm wrong. We had a target of 80-something dockets. We submitted just over 80 dockets to the National Prosecuting Authority for prosecution. Then in 2021, our target was 180 dockets, and we submitted just over about 185 dockets to the NPA. But you see, these dockets, some of them are minor, cases. So for 2021, we're not looking, for 2022, we're not looking merely at numbers. We are looking at the quality of cases that we investigate. We are emphasizing more on high-profile cases because the Constitution empowers us to refer matters to the ZRP. So some of these petty crimes that come to ZAC, we refer to ZRP. And there are many other complaints that come to ZAC of an administrative nature. So we refer to the relevant institutions, departments for further management.
So this number of 300...
I haven't finished.
Okay.
Numbers can be, I talked about, the targets that we had, when we submitted. They can be carryover dockets. But let me say, we are happy that the majority of these dockets are at different stages of processing in the criminal justice system. So they haven't been lost or thrown away. They're different stages of processing. Okay. So yeah, so that's all I can say. Okay, yes.
So the dockets are there, but depending on how you look at them and the numbers, and maybe they're carried over.
But the carryover dockets. But
you do not sit on dockets. I think this is what Honorable Melissa was saying. You're not sitting on them, right?
when we thoroughly investigate.
All right, Michael wants to come in there.
Indeed. You see, the statement by Honorable Mliswa was very simple, straightforward, and unambiguous. He said the NPA has over 300 dockets sitting. He went on to say it's a waste of taxpayers' money. I was head of English department at kindergarten. What that means is there are 300 dockets in a corner collecting dust and nothing is being done about it. That is where I said that is not correct. Whatever docket is in my office, something is being done about it.
Okay.
There could be 500, but they are not sitting. Those dockets are being attended to. Some of them are in the High Court. Some of them are in the Magistrates Court, in the regional courts. Some of them are in the provincial courts. Some are in Chitungwiza. There is not one docket which is gathering dust and an expense to the taxpayer. If that were to happen, then I really would be an embarrassment. We're working for an organization. That is an embarrassment.
Gentlemen, thank you. I don't know, Honorable Minister, I think we need to move on from this because we've discussed this. We've discussed this at length. Yeah.
We'll move on, but there's also no point moving on when we've not established certain facts. The whole point of investigating is to ensure that the Prosecutor General prosecutes in a certain time. Understand that, in a certain time. Maybe Mr. Reza can issue a statement to say the dockets which anti-corruption has given them have taken how long to see the end of the day. You cannot have a situation, that's what I'm saying, it's a waste of taxpayers' money. Not only that, evidence gets destroyed. People die. And when they die, there's no case to pursue. So for as long as they are not disposed of and there's no judgment, they are sitting in the National Prosecutor's Office. They can only not be said to be sitting in there once judgment and the case has gone for trial and there's judgment. So we must understand that the end of a case is judgment. Before there's judgment, the Prosecutor General's Office is handling that. I think we must be very clear about that. The other issue on PRAS, which I wanted to talk about, is, Praz, you are being unprofessional and dishonest to the president of this country. One, Praz must never be in anybody's office. Praz resides in the office of the vice president. I'm not saying that the vice president is a bad person, no. But from a discharge point of view, Praz must be totally independent. They cannot be in anybody's office. Because once you're in anybody's office, that poor person influences naturally. So why are you in the office of the vice president? Two, there are cabinet decisions which have been made for tender. Emergency case goes before cabinet. A good case is Honorable July Moyo on these pumps with Paul Kruger. They go before cabinet. Cabinet has no power over Praz. I'm telling you today as a legislator, you might not say it because you're scared you might be fired, but not me. Cabinet has no power over Praz. Why are you allowing cabinet to have power over Praz? Why is cabinet making decisions violating Praz? And why are you not telling the president the truth?
All right, so I think let me jump in there. Mr. Gondo, I'm not sure that you
must answer. You must, Andy, you must answer.
Okay,
why is cabinet presiding over tenders when they don't have the power to do that? Praz is responsible for that.
Let's get Praz to answer. Mr. Gondo, would you like to tackle that question, or at least some of the comments from the Honourable?
Let's deal with issues, Andy. That's what is important.
I've had the pleasure of meeting Honorable Mlisk on several occasions, and I must say he speaks from the heart. However, some of the issues are constitutional. When you have an act that says, a certain agency reports to the office of the vice president, the issue from a government perspective is that certain key ministries, commercial ministries, are all managed from the office of the vice president. And if people think that is not the best way to do it, I don't think it's really a debate that we can. It's for the principals to decide how to manage those things.
Okay.
Then in terms of the manner in which certain tenders happen, there are certain issues of national interest that when you have issues such as there's a crisis in terms of transport, Cabinet does not give a directive in terms of where to source buses from. But Cabinet sometimes says this is now a national procurement. So that in terms of dealing with that, where Praz can help, can facilitate the processes. I'm not sure whether that will be tantamount to interference or not, Honorable, but this is something that we can always discuss, that you can always engage
right.
with.
I think we can continue this discussion, but unfortunately I do want to get to the audience and to the participants to also ask questions. But I'm going to ask you all one final question. And let me start with you, Mr. Gondo, as you were the last speaker. This is the issue that Advocate Mudenda, the Speaker of the House of Parliament, mentioned. He talked about perceived policy gaps in the fight against corruption. I think he was very strong about that, and I think, Commissioner Makamura, you were at the meeting when he raised these issues. So from a Praz perspective, I appreciate that you follow what the regulations and rules tell you, but however, you must obviously give recommendations and hints and tips to your principals on what can be done better. So, in your view, what can be done better in procurement?
In terms of procurement, what needs to be done, I think areas of improvement is to enhance the objective of transparency. And like I alluded to, we need to make these processes electronic. We need to remove certain barriers. You will find that certain eligible bidders are failing to participate in these processes for reasons such as having to come from wherever they are to physically submit tenders. And sometimes when you create such barriers, it means that potentially good bidders are excluded from the systems. So we need to gravitate our processes towards electronic means.
Okay, thank you very much. Commissioner Makamura, let me ask you the same question. I'll ask you to be brief because I do want to get to the audience. What would be your comments? What are the perceived policy gaps that you see as ZAC that you would like changed, amended, or at least lobby the legislators who are here today to assist you to do that?
Let me say, The policy, legal, and institutional framework in Zimbabwe is quite strong, but of course subject to further improvement. So whistleblower protection, we are happy that the principles of the two pieces of legislation have been approved by Cabinet. But what we want to urge the members of Parliament who are here and the Attorney General's office, which is responsible for drafting, is now to speed up the drafting, gazetting, so that it goes through the parliamentary process. So that's a very important piece of legislation, because anti-corruption fight depends. Witnesses and whistleblowers are vital in any anti-corruption fight. If you look at our functions as ZAC, one of our functions is to make recommendations to government on measures to enhance integrity and prevent improper conduct. So what we do is we carry out research in various areas, corruption-related research, and then proffer recommendations. We have done that in mining, we have done that in public procurement, we have done that in public financial management, and recommendations have been submitted. Okay. Some of the recommendations are to do with further improvement in the legal and police framework. But lastly, it's not only the policy, legal, institutional framework per se that will not be sufficient. What is needed is enforcement of the statutes, the policies, implementation. This is where we also want to see further improvement.
Thank you. I'll leave you, Honourable, to last, but let me move to Michael Reza. Michael, we're talking here about policy improvements. I think Commissioner Makumura talked about court rules. They're trying to change court rules. You talked about catch and release, bail issues, which are constitutional, etc., and some of the hamstringing that you have, 4 lawyers for one defendant. I mean, Michael, surely the MPA must have come up with some form of recommendations so that we can start dealing with corrupt cases. Because let me be clear, the perception is that people are getting away with corruption. That's the perception. Whether it's true or not is not the point. Why? Because they're not really seeing prosecutions. They hear the arrests, they hear newspaper articles, but they don't really see, as Honorable Minister said, the end result, which is someone going to jail. And I know asset forfeiture obviously is a really good way of, hit them in their pockets. Michael, what would the MPA like to recommend to legislation, to the government, on changes that should be made to battle and tackle corruption?
At the risk of saying we are infringing accused persons' rights, really, the number of applications that are being made to the superior courts by accused persons, in fact, it's not all lawyers. I'm sorry to say this, but there's a number of lawyers whom I can count on fingers on my one hand, who are doing that, but they have the majority of the cases. But what we have done as NPA in the meantime, we have made certain decisions which are operational. I regret I cannot disclose what we have, but we have taken a decision where where we are.
You almost said it. You should have said it. You should have just said it. Yeah, should have just said it. Yeah.
Okay. What we have also done is all cases, as the dockets come, I sit with the prosecutors, those who are in Harare province. We look at the complexity of the matter, and I give the prosecutors. We have 12 prosecutors who are anti-corruption court prosecutors. We have 5 courts and 12 prosecutors. And we have 2 prosecutors for each case, so that no case is remanded because the prosecutor is not there.
So Michael, you said you only have 12 prosecutors for corruption cases. Surely, with the level of corruption, particularly in the public sector, is that enough?
That we have 5 courts, and believe you me, that number is manageable. That number is safe. We can work with that number.
So maybe that's why the 300 cases are sitting in there. Sorry, I'm only joking.
I know, but the truth of the matter is the number of cases that are packed at the High Court, at the Supreme Court. We even have two, I think, which are in the Constitutional Court. I don't know what that case is doing in the Constitutional Court, but we have two cases where an application has been made to the Constitutional Court. And what we do is, without fail, those cases which are in the superior courts, the prosecutor who is handling it in the magistrate's court must follow it. That's one of the strategies that we've done. Must follow it to the High Court, must follow it to the Supreme Court, so that the lawyer does not end up saying things which were not said in court.
So, sorry, Michael, I know, because we are running out of time, and I want to get Honourable Meliso for a few minutes for his response. Well. But surely it seems to me, and I'm sure to the participants, that it's really easy to dodge corruption cases. You just have to throw legal things. You've got to appeal. You've got to whatever. You get issued by some. I mean, it seems really easy. Surely there must be a strategy to try and make it harder.
They should, because in the High Court, the judge can say, "I'm giving you 20 minutes. Make your pitch." After 20 minutes, you are done. Unfortunately, the magistrate does not have that power. So a lawyer can ramble. Sometimes the magistrate will then have to say, "Look, you are repeating the same thing you have said." So they are buying time by doing that. But in the superior courts, things like that can be curtailed. Yes.
All right, thank you. I think it's obviously clear that the MPA needs to work with stakeholders to see how we can tighten up, particularly when it comes to corrupt cases. But I'm sure, hopefully, the MPA is on that and is coming up with suggestions to government. Honourable Meliso, I can only give you a few minutes, but really I want to talk about the policy gaps that I've asked the other participants on. And I also want to draw your attention, for example, to the expeditious amendment of the Criminal Matters Mutual Assistance Act, and of course the strengthening of the Reserve Bank of Zimbabwe's Financial Intelligence Unit, just among some measures that need to be done. Your comment on policy gaps, sir.
Now, to be honest with you, for the first time I've said I'm tired of passing laws in government, in parliament, which are not implemented. We're a country that enjoys change without review, without anything. Honorable Dr. Moyo said it here. All the laws are there. There's no enforcement. I'm just tired. Passing laws for what? When the current laws are strong enough and you're not implementing them, you're not enforcing. I mean, why should we be known as a nation that just writes and never implements, never executes? I am tired. For the first time, I have no desire of changing any law until we understand why the other law has not worked. You go from Zimaset, you go to TSP, you go to NDSA 1 within 5 years, and you don't review what went wrong with this policy for you to come with another one. So for me, I'm not interested in passing any law at all. The issues that are at hand are that why are these laws not being enforced? All these organizations taxpayers' money. If you go to the corruption courts right now, I hope he doesn't argue with me. Those judges and magistrates are actually tired of sitting. They have no cases. They're tired of sitting. There's no, and I say this honestly. They're tired of sitting. Yet we're giving them money. Okay, they're driving cars. They're doing everything. But they're telling you there is no case before us. So why do we have anti-corruption judges and courts when matters are not being taken to them? So really, these policies, let's not be a nation of just changing policy without review or laws and so forth. Let us enforce and comply with what we have right now. For me, I am tired. That's all I can say. But policies and laws.
Well, please don't be tired. We need your voice.
No, let us enforce.
We need your voice.
No, do you know what, Andy? It is a waste of money. Parliamentarians pass laws, and we can only do so much. But it's up to the people to enforce. And if you don't enforce, if you don't implement, what does it mean? Then you blame Parliament at the end of the day. That's the problem. Where you now have a problem with ZAC and the Prosecutor General's office. ZAC, for as long as they've not been given powers to prosecute, they'll always be blamed. Because the other arm is prosecuting. They don't appeal. ZAC investigates, but they don't prosecute. So ZAC must be given powers to prosecute so that they tell the end of the story properly. For as long as that, because there is fighting between these arms and the corruption is happening. There was SACO, SACCO was busy arresting ZAC officers who were investigating somebody. There is just mayhem. At times the disorder, you say, where is this coming from? Do we have order?
Thank you, Honourable. And I know for a fact, talking to Deputy Chair of ZAC and also John, the Commissioner John Makumue, that ZAC is exactly asking for that, if I'm not mistaken. They're asking for the ability to also prosecute, not just investigate.
Even that, because the Prosecutor General is corrupt.
All right. Well, anyway, of course, we've come to the end of this panel discussion under the theme taking stock of the scale and impact of public sector corruption in Zimbabwe. I, of course, would like to take this opportunity to acknowledge and thank our hosts and partners today, Transparency International Zimbabwe, Embassy of Sweden in Zimbabwe, GIZ, and the European Union. I do have a bit of time. I am going to use my power as the Master of Ceremonies to just shift the program just a tiny bit. So I do have a bit of time now to take some questions. I hope there are some burning questions. We have about, I can give us 5 to 10 minutes.
Thank you very much for this presentation. One of the ways in which collaboration becomes effective is when communication is clear. So if you ask me how many dockets are away right now, I will not be able to give you an answer. And so we had a very technical discussion around the number of dockets and so on and so forth. But what the people want to find out is how long will it take for corruption cases to be prosecuted, and what are the penalties for infringement. So the penalties for infringement must not only be for those who are acting corruptly. If in cricket you bowl slowly, your over rate is slow, you are punished for that. Meaning that you need to play to certain rules, even as ZAC or the Prosecutor General. I'm thinking here that then when we are when you're looking at court rules and so on and so forth, there should be a time frame within which the game must end.
Yes, my name is Sheikh Ismail Dua, the President of Supreme Council of Islamic Affairs in Zimbabwe. Now, my point is that, Mr. Reza, you have indicated that some of the laws tied his hands. Don't you think that we have got weak laws in Zimbabwe which need to be revisited? Then secondly, I want to address Mr. Makamure. Are you doing anything in the churches? Because we are just saying public sectors and civil servants. But the most corruption are in churches, especially non-governmental organizations, which are bringing things here with rebate free, purporting that they want to donate. Are you doing something, or have you got an arm which looks into the churches? Thank you.
Thank you very much. My name is Kumbulani Maposa from Matebeleland Institute for Human Rights in the City of Kings.
Welcome from Bulawayo. Welcome for coming here so quick. Give him a clap for coming all the way. Well done.
Yeah, but I didn't come corruptly bribing on the way. I think my question will go mainly to Honorable Mliswa. We have a constitution in Zimbabwe, and which is clear on devolution of power and devolving government services to the provinces and the districts, as the constitution puts. But up to now, what comes mainly from government is the issue of devolution funds, but not devolution of power. Because the constitution says devolve power, not funds. So as parliament, when are we going to see power being devolved so that we are able to curtail corruption at the local level? Because one of the strategies, if power is there at the local level, as citizens, we are able to hold the authorities at the local level accountable, demand accountability. But without that, it's difficult. So when is power going to be devolved? Thank you.
Thank you. My name is Jessie. I'm a commissioner in the Zimbabwe Anti-Corruption Commission. I want to just add my voice to support the panelists regarding the issue. I think it's an issue that was also raised here, the issue of time frames of the turnaround time for corruption issues. And I raise this because I'm happy that Honorable Mliskwa is sitting there. The Zimbabwe Anti-Corruption Commission has drafted a whole lay bill that is a proposed, a comprehensive legal framework for the overhaul of our anti-corruption legislation in Zimbabwe. That involves primarily the repeal of the Anti-Corruption Act that is there now, that was passed when there wasn't an independent commission that is there now. That also lags behind a lot of anti-corruption, wonderful devices and and tools that have since been adopted all over the world in the international framework. And one of the things that we are proposing in that particular lay bill, we prepared it, we've submitted it to we've made life easy, let me say. We've actually haven't said we want new legislation. We've actually done the homework to say, this is what we'd like it to look like if we're going to be effective. And one of the things that our proposed legislation does is to deal with that issue of time frames. We are seeking to borrow from the electoral act. I think section 128 in the Electoral Act provides that all election petitions must be completed within 6 months of them having been filed. So we've not only borrowed from that, but we are improving upon it because we want to propose that after the case is finished, there's a conviction, hopefully, then any appeal should be concluded also within 6 months. But alas, our bill has, we don't know where it is now. It's been, it's been orphaned, and we'd really like to, because that would also assist Mr. Reza and his courts in the NPA, because my own view is that, personally, frankly, I don't think that if we amend the rules of court without actually changing the statute itself, the statutes that require people, I don't, personally, it's nice, but I don't think we'll go very far. Because the rules would be a statutory instrument, but a statutory instrument of what? So if election petitions go very well, they are done and they are finished within the time. And this is what we'd like. So from the Zimbabwe Anti-Corruption Commission, we'd really like, because even issues around the whistleblowers that we are talking about, our proposed bill that we think would, if Zimbabwe was to, if it was adopted by government, because they're the ones, the executive is the one that brings bills to parliament. If it decides, if it agrees with ZAC and adopts our lay bill and drafts an actual bill and is taken to parliament, and we're happy that Honorable Mliskwa is there, that they'll take it. But for now, we've been sort of going on, and your parliament is about to end, and we'd like you to pass this before you stop sitting in the 9th parliament.
Well, there's the appeal from ZAC. Thank you for that, Jessie.
Thank you, Chair. My name is Fiona Magaya from the Zimbabwe Congress of Trade Unions. My question is on the authorities, the top government ministers, the top gurus in the private sector who have been accused of corruption. We have not seen the end of those cases. As ordinary members of the public, we deserve to be given information. So I want to reiterate what my brother has said, that communication is key. How have you communicated to the members of the public what has happened to those cases? And what forms of communication are you using to communicate to the members of the public? Because I'm talking about my grandmother in the rural areas. I'm talking about my grandfather somewhere down there in Binga or somewhere there. How will those people know that these cases are being dealt with? Because I believe that we need to make deliberate efforts to empower the citizens to be able to hold their authorities accountable. Thank you.
My name is Sandra Matendere from Zimbabwe Women Against Corruption Trust. My question is directed to PRAS. What efforts are you making as PRAS to make sure that public procurement system is transparent and free from political interference to avoid awarding tenders to non-existent or incompetent companies? Thank you.
Thank you. My name is Tabora James. I'm a lecturer in law at UZ. I have a quick question to Praz as well, Mr. Gondo. You said the only recommendation you could give on improving the procurement system is e-procurement. Section 54 of the Act says the Auditor General sits in what is called the SPOC. You know SPOC, right? So SPOC is a committee, is an organ that considers sensitive contracts or bids. And the Auditor General is a member of that committee. And the Auditor General must be independent and must scrutinize independently all contracts in Zimbabwe and not be part of any organization that gives awards. Is it your position that we don't need to change that part of the law and only focus on e-procurement? Thank you.
My question is on the deteriorating service delivery in our local authorities. You see, the question of evolution that has been mentioned earlier, in terms of section 301, subsection 3 of the Constitution, it stipulates that at least 5% of the annual budget of a country is disbursed to local authorities and provincial councils. And now what we are witnessing in the rehabilitation of our roads is the direct involvement of state agencies in determining which roads to undertake. And the jobs done are of a poor caliber. Look at the different roads that have been made. The contracted companies are the same that have previously been mentioned in the Auditor General's report as having failed to deliver. Why is it a trend that incompetent road construction companies continue to receive government contracts? Who is behind those companies? And we think that the fight against corruption is incomplete without the exclusion of these incompetent companies from future contracts. Praz, can you please attend to this? For example, in Harare, we have the biogas digester in Mbare that got $500,000 US. The company that failed to complete that project has been given 2 other contracts in Harare. And if the PRAS is the regulator, why has it been that this company in 3 shapes, using 3 different names, has continued to get contracts but does not deliver? And we are talking of fighting corruption. What is happening? Is there collusion between your officers and officers in the city of Harare? Thank you.
Thank you. That's Precious Shumba, of course. He didn't introduce himself.
Oh, sorry. My name is Precious Shumba. I'm the director of the Harare Residents Trust.
Okay, so let's start from the top. I think Commissioner Majome talked about the ZAC bill, talked about speed. Maybe you could make some notes, speed or timeline of prosecutions. And also, I think Masimba talked about what are the actual penalties for that. I think that's an important question. I think we'll go through them one by one. So, speed of prosecutions. The deputy chair of ZAC talked about 12 months. He'd like to see cases done in. Michael, I think, do you want to take that one? Very, very briefly.
Thank you very much, Andy. It would appear what Commissioner Majome was suggesting is exactly what we are doing in the NPA. As I was answering a question, I don't know how I stopped, but I had said when dockets come, I sit down with prosecutors. We look at the complexity of each case, and we only have 2 time frames. Either that case must be completed in 6 months, if it is not very complex, or in 12 months if we believe that it is fairly complex. It is a rule of practice that we are implementing.
Okay.
Yes, that is the question.
Thank you. And also, while I have you on the microphone, a comment was that you have, is it about having weak laws? Do you think that the laws need to be revisited?
Yes. I do not believe that we have weak laws. As a country, we have very good laws. But what is happening is some lawyers are not using the laws. They are abusing those laws. For us to remove some of the rights, for example, the right to appeal, I believe we can do that, but in reality, we are trying to get by the back door what we cannot get by the front door. And I do not believe it is proper. What we need to do is to have laws that deal with those lawyers or prosecutors or whichever party, the accused or whatever, who is abusing those laws. I can tell you now, I have a case where I have had to deal with 49 different applications. 49, as in almost 50 different applications.
All right, okay, let me move over to Zach now. John, some of the questions that came out, I think one question from the back was, why are you not also looking at churches, which I'm told that allegedly there's big corruption in churches, and also NGOs? Is Zach looking at them?
Yes, we are. In fact, the gentleman in his remarks, he actually said he's a member of the subcommittee on citizen awareness and empowerment. So let me explain. The National Anti-Corruption Strategy has got 6 thematic areas overseen by 6 subcommittees. One of the subcommittees is to do with citizen awareness, and he's actually a member in that committee, very active member. Then I've got Bishop Chikuni. Where is he? I saw him, he's gone out. Also a very active member. So the churches are a vital partner. We work closely with them in spreading awareness. If there are corrupt issues in churches, please reports must come to Zach. Help us with the reports. We'll investigate. It doesn't mean that if you're a member of a subcommittee or a steering committee, then you are immune from investigations.
Okay.
No, it doesn't mean that.
So you will, you are taking, or you will?
Yes, we work very closely with the churches. Excellent. We investigate, corruption in those areas.
John,
then ZCTU.
Yeah. Well, let's. I want to come to that question from Fiona, I believe, from ZCTU. Her question, of course, was that we do hear of all these top political elites being accused, possibly being arrested, but then we don't get any information, communication about the results or info.
No. The commission is very active on Twitter. I'm sure as ZCTU, I don't know if you follow our social media pages. If you don't, that's not our fault. Then we have got a radio program on Radio Zimbabwe every Wednesday. 3 p.m.
Do you have a website that says position?
Yes, we decommissioned the one that was there. We are at the moment finalizing a new website. Then ZCTU is a member of the National Anti-Corruption Strategy Steering Committee. The former president, Mutasa, attended, I think, 1 or 2 meetings. When he left, ZCTU has not been active. It's a member of that high-level steering committee. ZCTU must participate in the other subcommittees. So there is the steering committee at a high level, then subcommittees 6, where stakeholders can choose where to participate. So we are calling upon ZCTU to be active so that issues that are discussed in the steering committee, in subcommittees, they help us as a partner to further disseminate to their constituents. This is how we can disseminate information, expecting Zach alone to be able to reach everyone in this country, every corner of the country. I think that's expecting too much. So that is the strategy. Let's work with our partners to further disseminate, so be active in the subcommittees, in the steering committee.
Thanks, John. I have to jump in there. Mr. Gondo, I'll come to you. There's a few questions that came from you. Precious, I believe. Precious Shumba, he talked about the deterioration of service by local authorities and why PRAS does not exclude those companies proven to have failed or to have not satisfied previous tenders. He mentioned the case where someone had failed, but they got 2 new tenders after that. Your comment?
Thank you very much. I think, again, because this is a legal process, the rules are clear. Contracts should only be awarded to bidders that are eligible and are qualified to perform the contract satisfactorily. So when we have situations where bidders who do not have the capacity or the capability or the expertise to complete a contract, it means that the wheels would have come off. These are issues where the law provides for debarment process, But I must also hasten to say, the moment a private bidder or a private sector enters into a contract with a government entity, it becomes a contractual relationship. That must naturally end up in the courts. We do have rules for debarment. The state entity must raise a complaint, we investigate, the rules of natural justice are followed.
Right. But I think the point Mr. Shumba is making there is that the wheels must be falling off, because if someone gets a tender and doesn't perform, but they can then apply for another one and another one and another one and get it given to them, there's obviously something, there's a gap in the system.
No,
I'll come to you because there's a few more questions for you as well. Thank you. On Praz, one more last question for you, Praz. Spoke. There was an issue from a lecturer at the University of Zimbabwe talking about the Spoke Committee. And whether, I think you've heard the question. Can you respond to that?
Okay, SPOC stands for Special Procurement Oversight Committee. The rules have provided whereby, because procurement is now decentralized, and Parliament was worried that with the decentralization of procurement, the State Procurement Board to the state entities, there was also decentralization of corruption. So SPOC was created as a safety valve. It's a high-level committee which is chaired by the Attorney General, deputized by the Accountant General and the Chief Director in the Ministry of Public Works, and any other member that they so wish. The law as it was written also provides for the Auditor General to sit in that committee. That mistake was realized the moment the law was promulgated. She has never sat in that committee. She recused herself for obvious reasons of conflict of interest.
Okay.
If you follow the news, last year or 2 years ago, Cabinet approved principles for the amendment of the Procurement Act, and this is one of the issues that are subject to be changed.
All right, and of course, the final question before I move to Honourable is, of course, the transparency from Sandra. I understand efforts to ensure public procurement is transparent and there's non-interference, political non-interference.
Okay. In short, let me say, public procurement is a politically sensitive area, whether in Zimbabwe or in all parts of the world, because of the magnitude of the monies that are spent. The Act has provided under Section 16 to deal with issues of political interference. They provide, because the decision to award contracts is now rested within the accounting officers, the heads of the ministries, the heads of the parastatals. Right. So Section 16 provides that should they be facing any interference, there are channels of how they should handle that.
Okay, thank you. Right, Honourable Maliswa, there's a few questions for you. I hope you have your pen, sir. The first one, of course, was the devolution of power, whereas now everyone is talking, government's talking about devolution funds going down, but not power. When will that occur so that at local level, corruption can be tackled? That's the first question. There was also another question about the ZAC bill, which seems to have died a death. I'm not sure if that's the right word, Commissioner Jesse, has died a death, and what's happened to it? That's the second question. And I think, and of course you had the comment on some of the other issues that were asked. Over to you, sir.
Okay, let me, first of all, I wanted to come in there and say, Gondo is a civil servant, he has a family, and he must keep his job. That was a question from Mr. Precious Shumba about the companies which keep getting contracts, yet they're not performing. That's the corruption which is there, and that is the corruption done by politicians, okay? And unfortunately, it leads to the next question, which was asked about devolution. How are you going to devolve power? Something happened in Parliament yesterday, which I'll tell you, which we've been pursuing. Devolution, why would one want to give money where there are no structures? 264 is very clear. There should be provincial councils in place and all others. And for the first time yesterday, and I hope Zach, and I joked in Parliament and said, I'm going to get Zach to arrest Honorable Marion Chom, because he admitted that there's been disbursing money without an enabling act. You see? So it's on the Hansard, and it's there, it's in the public. She said, we have been disbursing money without an enabling act. While Treasury gives you money to do ABC, there must be an enabling act which makes sure that these structures you're talking about are critical. 264 talks about these committees being responsible for evaluation and monitoring. So who's monitoring and evaluating? No one. So they take the money, it comes from the Minister of Finance, rightfully so, is dispersed the money, but where is the enabling act? It's not there. All this money that you see going, central government is directly paying companies. And I hope anti-corruption is on it. There's no ways central government can directly pay a company when there is devolution. So to me, and I'm very clear about it, and I've said that Honorable Jujulaimo has been laid down by the Attorney General's office. The Attorney General's office must be guiding ministers. But of course, they're also tired. They don't go to jail. It's the minister who goes to jail, so they watch. This is the situation we have in the country, sadly, that people have decided to fold their arms and allow those making mistakes to make mistakes, because us politicians seem not to learn from the First Republic. The lessons we have not learned. In fact, we've gone into overdrive. I don't know why. Dr. Moyo was very clear. May these institutions be depoliticized. For as long as these institutions are not depoliticized, it's a problem. The next question from Commissioner Manjomi is very clear. Commissioner, which minister wants to lose power, or which minister wants to go to jail? That bill will take some time. Because the entire cabinet, most of them, will not be there. So it's a delaying tactic, and I appreciate it. There is no ways they will bring a law that will get people. We are going towards elections, and people are watching. Some of these things are political. They've got to suspend them because it will expose a lot. That's all I can say.
All right, and I think on that note, we have come to the end of our panel discussion this morning. Of course, I'd like to thank our hosts and partners, Transparency International Zimbabwe, Embassy of Sweden in Zimbabwe, GIZ, and the European Union. I'd like to thank our guests today, Commissioner John Makamura, ZAC spokesperson. Thank you, John. Michael Reza from the National Prosecuting Authority. Michael, thank you very much. Mr. Gondo from PRAS, thank you, sir, for giving us your time. And of course, Honorable Themba Moliswa, African Parliamentarians Network Against Corruption, APNAC chairperson. A final comment, if I may. It is clear that the challenge and eradication of corruption in the public sector requires an holistic approach and broader discussion amongst various stakeholders. More importantly, action needs to be taken against those who are corrupt. Action must not only be seen to be done, but those who corrupt must be prosecuted successfully. Corruption in Zimbabwe must not be seen by the corrupt as something that you can get away with and that they are untouchable. Zero corruption must be the goal, and zero corruption must be what Zimbabwe strives for and achieves.